Okay, good morning, everybody. First and foremost, thank you for attending. Thank you for your time. Very popular topic. And for that reason, we're going to do things a little bit differently today because ordinarily I love an active participation with crosstalk, but with over 100 people on the Zoom, as you probably saw from the grid, that would be a bit cumbersome. So how we're going to do this today, again, I like questions, happy to answer them as we go along. I know there are going to be a lot of them. But first of all, you can, there's a chat feature that's enabled. So by all means, pop up a question in the chat. What I'll do is I'll go over every slide and then I'll look at the chat. And if there are any outstanding questions, I will answer those questions as they come. Again, some of these questions that will be asked, they will be answered in later slides. Some will not be answered at the time, but I'll answer them a little further down the road. Some of them, Department of Labor, still, this is a work in progress, people. So Department of Labor, they understand that this is a brave new world, and they're just as new to it as we are. So some questions I won't be able to answer, but that being said, I'll do my best. If you don't want to pop up a question in the chat, don't worry, I'm not going to call people out by names, but I think the chat does that for everybody. So you have my email address, gspaun, GSPAUN, at WB&G LLP.com. And this presentation on prevailing wage and the New York Contractor Registry and the new requirement for filing certified payrolls for both New York's private and public construction. This will, you can shoot me an email, chat, whatever, as far as, questions. I'm happy to take them as they come along. And that's not limited to just today. If you have a question down the road, by all means, reach out. I say that this program has my lifetime guarantee. As long as I'm alive and practicing law, I'll answer the question. So with that, I think we can begin. Let me just, my apologies, a couple last minute stragglers, but at this point we'll start our program. So since I do see quite a number of people, even some new faces, we're going to go into prevailing wage overall, but eventually we'll get to the meat of what a lot of you are here today for, and that's what's new circa January 1st. So basically, what's prevailing wage? I mean, again, we know and love this, as it were. We'll go into this briefly. Prevailing wage on federal jobs is governed by the Davis-Bacon Act, enacted in 1931, and it requires contractors and subcontractors working on federally funded jobs to pay their laborers the wages and the benefits no less than what others locally pay their workers for similar projects. Basically, it's denominated as prevailing wage, and it's supposed to be the average prevailing wage in the area. As a practical matter, it generally gets determined by reference to negotiated union collective bargaining rates for the work covering the jurisdiction of the work and the locality. A lot of times, if a Department of Labor inspector has a question as to what the prevailing wage is, they'll call up the local union business agent for the appropriate jurisdiction. Hey, what are your wages? And that will more often than not be what the wage is. New York State has a very similar statute, Article 8, Section 220, etc. of the labor law. It's the same purpose as Davis-Bacon, and it applies to projects for the state or a public benefit corporation, a municipal corporation, or a commission appointed pursuant to law. Basically, that's your traditional public works project. Something more often than not with a flagpole outside the building, courthouse, a schoolhouse, police station, and whatnot. We all know what these are. And if you're working on these open shop, there are problems for you. So I don't think that anybody falls into that category. But at the end of the day, you just need to be aware of that. Similar to how prevailing wage is determined on federal jobs, it's determined on state jobs pretty much the same way by reference to local union rates. State Labor Law 220 also applies to direct and subcontracts. So if you're a prime contractor, general contractor on a traditional prevailing wage project, you know that your subcontractors also have to pay prevailing wage. You don't get around prevailing wage simply by subbing it out to cheaper labor. That would defeat the purpose. And again, like I said, it's determined by reference to union rates. We'll just refer to this as mom and apple pie prevailing wage. We all know what it is, and we all love it. New York has not so recently expanded prevailing wage. This came in a couple of years ago. And what it does is it expands it to covered construction projects performed under a private contract. Now, what does that do? What's a covered project? Big question. Particularly if you're going to be required to pay prevailing wage. Again, there's a flagpole outside, it's a courthouse. You know you have to pay prevailing wage. Well, what about on these private projects? How do you know? Well, it's determined by whether the project is paid for out of public funds, and that's determined in the statute. Public funds have to comprise more than 30% of total costs and cost more than $5 million. So, okay, what's paid for in whole or part out of public funds? To use a vernacular, if the project's getting some government cheese, if it's getting some kind of a government benefit, such as a payment, not subject to a repayment, a grant, savings in the form of tax credits, reduced fees, pilots. Now, a pilot, it's listed in the statute. Yes, there is an argument, and a good argument in my opinion, that a pilot is not really a savings. It's the incentive that was put on the, that was given by the public owner, and through negotiations with the developer, who originally said this project would cost too much in the way of taxes if I go forward with it. So in order to incentivize the development, the government agreed to make the project, the parcel tax-free, and instead require a payment in lieu of taxes. Pilot. Again, we can have that argument till we're blue in the face. The fact is it's in statute. If there's a pilot applicable and it meets the other thresholds, it's a savings, and it can kick the project into a prevailing wage project. Also, contingent loans, credits applied against repayment of financing, some affordable housing benefits. And again, the big question is, how do you know whether the owner is receiving enough government cheese to put it in the category of a covered project? You know, that's your big question as to whether you're going to bid this prevailing wage or open shop. The owner's going to want the lowest cost, and you can give a lower cost if it's not a prevailing wage job. But you don't want to be left holding the proverbial bag by having agreed to an open shop rate and then be told, oh, by the way, and that being told is usually, you know, a proverbial gunpoint from the Department of Labor, that by the way, you have to pay prevailing wage. The owner may have an incentive to misrepresent the prevailing wage status of the project. They do. They want the project done as cheap as possible. So how can you protect yourselves against that? How do you know whether the owner is receiving public funds or whether it's a covered project? These are the first two things you need to know in order to protect yourself. Obviously, if the owner says, by the way, it's a covered project, you know you have to bid at prevailing wage. And if you don't, you're doing so at your peril. Again, the owner has an incentive to misrepresent that. So if they come clean and say, yeah, I'm prevailing wage, look, everybody knows what's going on. You know how to bid it. You're going to bid the higher price. You're not going to get caught. But if the owner says, no, don't worry, it's not a covered project, you want to have that owner make an affirmative representation as to whether it's receiving public funds. Have the owner make an affirmative representation as to whether the project is a covered project. Basically, the representations, which I like to put in affidavit form, because if they're false in an affidavit, there's a term for that. It's called perjury. So that would give you a quick fraud claim against the owner who makes such a misrepresentation. So you want the affirmative representations that the owner knows is representing that it's not a covered project, that it has not received sufficient public funds to put it in that category. It knows that the contractor is bidding this as a non-prevailing wage project and is relying on those representations. So once you get those representations in your contract, and again, I like them in affidavit form, you have the protection when there is a misrepresentation. And in the contract, you want to get an indemnification from the owner if these representations are false. And again, by false, I don't necessarily mean fraudulent. The owner may have been mistaken, him or herself. So, but the net effect is it's a covered project and you've bid it and have obligated yourself to pricing it open shop. So what you want in the contract is a clause that in the event the Department of Labor determines that this is in fact a prevailing wage job, the owner will hold the contractor and any subcontractors, etc., on the project harmless from the effects of converting it mid-job to a prevailing wage project. And that conversion would be you have to go back and pay your employees the difference in prevailing wage. And you also want to importantly include a duty to defend. Duty to defend, that's me. That's the cost of an attorney to fight and or negotiate and or help resolve the issue. Again, you want to pass along attorney's fees and any civil penalties, and make sure that the owner is the one who should have told you that it was prevailing wage in the first place and didn't, and thereby they're the ones paying the cost and not you. There are exclusions to the statute. We will breeze through these relatively quickly. Affordable housing, for obvious reasons. Funds that don't directly finance costs of construction. Sewage system funds used to construct them. Renewable energy, broadband, climate risk, because they're covered, they're included elsewhere. Tax benefits not able to be calculated at the time of work. This is a big one because as a part of the project, there may be certain reductions in assessments or whatnot that will be in the future that are largely dependent on the income producing ability of the project, which is estimated at the time of construction. If it weren't estimated, the owner wouldn't be doing the project after all. They're looking for these benefits down the line, but they're not able to be calculated with any precision. So fortunately, the statute takes this into account, and it doesn't require that you have your proverbial crystal ball and be able to make calculations that are simply not calculable at the time. So there is that exemption. Funds determined exempt by the Public Subsidy Board. Well, we'll get into that momentarily. Brownfield remediation projects. If you're doing something like remediating what used to be a factory, a plant, or whatnot, and doing some environmental cleanup, that's a good thing. We want to encourage that. So there is that exemption. Not-for-profits, trailer parks, renewals, charter schools, 1 or 2 family dwellings, union and PLA projects. Well, they're exempt for the obvious reason they're going to be higher than prevailing wage. By and large, all in. So there's no need to add that burden. Small school projects. Now there's a real, basically, small school projects. And again, this is, for certain, smaller private schools. This is not public schools. Public schools are prevailing wage work. I have some questions that have come in. I'll get to those a little bit down the road. But in the meantime, let's talk about the process of making the determination. Your owner will they will certify that the project's a covered project and subject to prevailing wage or not. Again, if they say it's a covered project at the outset, the analysis ends. It's a covered project and you're paying prevailing wage. If the owner has doubts, what they do is they apply to the newly created Public Subsidy Board to determine whether the project is in fact a covered project. The decision of the PSB is not reviewable by the Department of Labor or the Commissioner. The Commissioner sits on the PSB, but the Commissioner in the Department of Labor doesn't serve as an appellate review for the PSB. Its decisions are reviewable via an Article 78 proceeding, not via the Department of Labor. Now, the Public Subsidy Board, as comprised, it's heavy on the labor representation versus the building representation. But that being said, the construction industry had some trepidation when these announcements were made as to the appointments, as to whether they would indeed be fair. But as it's worked out, they call balls and they call strikes. The 8-4 tilt in favor of labor hasn't shown up in their decisions. So, kudos to them for looking at everything on the merits and basically being that neutral umpire that the owner and the industry is looking for. So once it's certified or not by the PSB, you know whether you're paying prevailing wage. Once it is a prevailing wage project, the owner has to retain certified payrolls for 6 years, subject to inspection. And again, we'll get into the requirement to file them electronically with the Department of Labor. But as for the owner and the upstream contractors, for wage theft purposes, you're going to want to keep receiving them anyway. You're going to want to put that in your contract. It's already in there because now they have to be submitted on existing projects starting January 1st to the Department of Labor. But prior to that, you had to collect them from downstream. So the requirement's in there. You want to keep the requirement in there so that if there's a wage theft issue, you've got documentation to potentially protect yourself. Don't let a subcontractor, don't let a lower tier say, hey, I filed it with Department of Labor, you don't need it. Well, that might be true for submission purposes, but for wage theft purposes, it's not. So therefore, I still need them. It's in your contract. You don't do it, you don't get paid. The public entity providing the funds must also advise the owner whether the funds are covered or exempt. Again, you want a fair determination as to what's prevailing wage and not. And, you can't have the public entity, kind of popping in. Oh, by the way, that, there were strings attached. That was official government cheese or not. You want to know that up front. Covered private projects must now adhere to MWBE utilization goals. What's the prevailing wage rate? Well, rates are rates. The rate of a mom and apple pie prevailing wage project for, say, Westchester County or Albany County or, New York City, it's the same regardless of whether it's a private project or a public project or whatnot. Here's a wage rate that I just picked out at random. These rates, as of June 1st of 2025, it's 49, which makes it 51.90 plus those are your fringes. That's still the rate. So again, there is no question to be asked, okay, how much prevailing wage do I pay? All of it, if it's a covered project. What are other covered projects? Well, again, renewable energy projects that have a capacity over 1 megawatt, thermal projects, offshore wind farms, transmission facilities, and again, similar to the other covered projects under 224A, union PLA projects are excluded, must adhere to MWBE goals. Here you have an added requirement that apprenticeship agreements are required. So keep that in mind if you're working on one of those. 224E is broadband projects. Again, with the advent of satellite internet, this is not as in the forefront as it once was only a few years ago. The idea was to provide service to underserved areas, but when you can have a 2-foot square satellite dish looking at the sky and get broadband internet, it's a lot easier than running wires. Other covered projects, Section 224F, the first. I use the term the first because apparently somebody who drafted this particular statute didn't hear that song when we were all kids, A, B, C, D, E, F, G. So there are two Section 224Fs. The first one is a climate risk energy transition project that receives at least $100,000 from the Climate Action Fund, which is, as we know today, is nothing. Union PLA projects excluded, affordable housing and 1 to 2 families excluded, and you've got to use apprenticeship agreements. The second section are for roadway excavation projects. This has caused a little more in the way of consternation among the construction industry. And it applies where a utility company needs a permit to open a roadway. So if you're working as a sub to a utility company, you need to find out, the conditions of the permit. The statute requires that the municipality make as a condition of the permit issuance a requirement to pay prevailing wage. So you want to make sure that prevailing wage applies. Now, as this has been interpreted, you have open shop, your straight rates up until the end of the roadway, the right of way. Once you're in that right of way, you're prevailing wage. You get across the street, across the roadway, highway, you're now back in private property, and across the right of way, you change back. So there is a little more record keeping, but if you're just going right across the street, that record keeping may be worth it. On the other hand, I've got clients that do this kind of work that are constantly in and out and in and out. And for ease of paperwork, they just say, it's all prevailing wage. Now, prevailing wage is a minimum wage. You will never be faulted by the Department of Labor for paying more than prevailing wage, but your bottom line may say otherwise. Aggregate, this is a big one that came in. Labor Law 220 sub 3AF. This is the statute in its entirety. Prevailing wage shall be paid for work performed on a public works work site pursuant to this section involving any delivery to and hauling from such work sites of aggregate, as well as any return hauls, whether empty and or loaded, and any time spent loading and unloading. So it's basically the minute your truck shows up to pick up, all the way down, all the way back. Now, prevailing wage is determined by the work site. So if you're picking up materials in Ulster County for a job down in Westchester County, you're paying Westchester County rates, even though your first times are working in Ulster County. And again, it's the return haul as well. So you got to make sure to price that out. I see a question. Okay, Bonnie, I will get to this a little bit later on. As far as your shop, that's something new as of January 1st. So it's a good question. I'll get to it in a few moments. So there were a lot of questions raised and a lot of ambiguities in that statute. Department of Labor came in and promulgated regulations. Where'd they get it? Well, they pretty much got them. They made them up. I mean, the industry needed something and they provided it. Now, some of these have been to the consternation of the construction industry. DOL has defined the work site as the site plus surrounding areas supporting the site. Okay, you're doing a highway job up on the thruway at mile 50. You've got a big wide open median at mile 60 where you can stockpile your materials. That's part of the work site. That's a logistical thing. So that's supporting the site. Central stockpile. You've got a couple of jobs going on, and for logistics, have a parcel of property somewhere in the middle that you're going to and from. So DOL has defined a central stockpile as a location meant only for use on a specific public work project are kept, and sites for centrally stockpiling. Aggregate, it's defined aggregate: sand, gravel, stone, crushed stone, dirt, soil, millings, and fill, which is what the industry typically thought of as aggregate. But again, now the fight is not to be had. This is what you pay prevailing wage on. So if you're hauling concrete, with an exception we'll discuss later, it's not aggregate. Application, it's 50 miles radius of the work site. This is the most controversial regulation because there's nothing in a statute about this kind of an application where you go, to, from, and importantly, it's the proverbial as the crow flies miles. It's not odometer miles. So you're going, if you have a windy road, you're going up and down around a mountain, your odometer says 65 miles. You may be only 40 miles from the work site. So keep that in mind. It's like what we all learned in 3rd grade with the protractor going around in a circle and scribing. That's the radius. And again, it's the rate of the county of the work site, regardless of the actual counties traversed. It does exclude out-of-state travel. So if you're doing a job in Albany County and getting your materials from someplace in Berkshire County, Massachusetts, when you cross the state line is when the prevailing wage clock goes on. It does exclude stockpiling for an undetermined future use. This is typically for your towns, who have highway departments who stockpile for pothole jobs, or they stockpile sand and salt for the winter. You do get one delivery by a vendor-employed driver per day that's excluded. One and only one. Okay, let's. I have a couple questions. Can you get access to the slides? Absolutely, I'll send those out. New guidance and concerns to the 50-mile radius? Nope, 50 miles is 50-mile radius. That's DOL's not changing their mind. Yeah, well, here's a question about union. The PLA is not covered. Does that they are subject to certified payroll reporting, but they don't have to pay prevailing wage because their union rates are prevailing wage. So when it comes to certified payroll reporting, they are a covered entity. If you're paying prevailing wage, or if you're working under a union agreement on one of these covered jobs, then yes, that you would have to make that reporting. This is new. Downstate Concrete and Asphalt. This is Labor Law 223 AG. This is a very similarly shortly worded statute. Copies a lot from the preceding section. Prevailing wage, perform public works worksite pursuant to this section. Delivery to, hauling from a concrete and asphalt, as well as return hauls. Whether empty or unloaded, time spent unloading. And this is counties of Nassau, Suffolk, Putnam, Westchester, and the city of New York. It defines concrete and asphalt because those were excluded from the Department of Labor regulations. So now if you're in a downstate region, this is something you have to price in. Again, return hauls, time loading and unloading. This is your geographic area. If you're north of Putnam, if you're west of Westchester, Rockland County and north, you're good to go as you are. However, if you're working in a downstate region, this is something you need to price out, and this is effective January 1st. Will the Department of Labor regulations we just went over apply? My gut says likely. They haven't been specifically incorporated. My thought is you can't go wrong by hewing to those regulations and adhering to them. If Department of Labor comes and says, "Hey, look, where'd you get this idea? Hey, these were your rules." It's a good faith defense. It negates any kind of a willful intent to disobey the statute. We don't know that. Stay tuned. But again, if I had to put a couple of bucks on it, I would say yes. This is also new, and this gets into a previous question. Custom offsite fabrication. This is something that was opposed strenuously by the industry, but nonetheless, it was signed by Governor Hochul. It creates a new section, Labor Law 220 sub 3F. Prevailing wage applies to custom elements solely and specifically designed and engineered for installation in the construction, repair, renovation of a building. This is important, which is subject to a contract with the state, department of the state, board or officer in the state, municipal corporation, or commission appointed by pursuant to law. And it applies to contracts put out to bid by one of these entities after June 16th of this year. This is mom and apple pie prevailing wage. These are not the private covered projects. So if you're working on one of those, you don't have to worry about custom offsite fabrication. Again, flagpole out front, mom and apple pie prevailing wage. This is going to apply provided the bid was put out after June 16th of 2026. Solely and specifically designed and engineered. Now, the fact is that Department of Labor is looking, and the statute, they're looking for your custom decking, prefab decking, and structural components, your duct work, some of your facade, and ultimately, you can see the progression. Some of these are more and more off the shelf, but may require some modification, such as HVAC. The questions will come up, will arise, and will ultimately be litigated. And they will, we will obviously keep the industry informed. But the question will arise and will ultimately be settled. Okay, how much alteration makes an off-the-shelf unit solely and specifically designed and engineered for this installation. A couple questions. Does that mean that fabricators need to be paid prevailing wage then? Yes, we'll get into that. Again, provided it's a mom and apple pie prevailing wage job, off-site fabricators do need to be paid prevailing wage. Question about a PRC number, we'll deal with that later. Here's a good question about if fabrication is in Canada, do you have to pay prevailing wage? Well, yes. Moreover, that Canadian entity has to be registered as a prevailing wage contractor. So, the question will arise that as to how do you calculate prevailing wage in won, in yen, in Canadian dollars, in rupees, or wherever euros, wherever the fabrication is undertaken. The rate is at the site, and again, it applies to wherever it's done worldwide. There's no border requirement on this statute. And these contractors, these suppliers now have to register as prevailing wage contractors. So how do you plan on getting that Chinese firm, that Indian firm, that Vietnamese firm? We're increasingly seeing more materials being constructed there, that Japanese firm to register as a prevailing wage contractor. So your specifications call out for Mitsubishi equipment. Mitsubishi, Japanese concern, Japanese manufacturer. Mitsubishi now will have to register as a prevailing wage contractor. Again, this is a brave new world, like I said. But as the statute is written, if the fabrication is in Canada and other countries, yes, they have to be paid prevailing wage. They have to register as prevailing wage contractors, and the prevailing wage to be paid is the rate of the site. Okay, sanitary manholes, that a part of building construction. If you're doing it on a prevailing wage job, then yes. If you have field guys working prevailing wage job, fabricators making different things each job, would they be considered off-site fabricators? Absolutely. If you have your own shop somewhere else, then that's an issue. Because obviously, for ease, for efficiency and for ease of manufacture, you are you're putting forth, hey, I need 12 of these lengths and 10 of these lengths. You're putting in overall orders for your factory, for your shop. The workers there don't know where these are going. You will know, okay, 3 of these go to this school, 4 of these go to this private office, 3 more of these, go over here. So, how do you do this? How do you segregate it? It's going to be an administrative nightmare. Okay. Just confirming 224D projects don't fall under custom fabrication. Correct. Mom and apple pie prevailing wage. Who at the manufacturing plant is paid the prevailing wage? Is it the line of who touches the project? Yes. Anybody who's manufacturing those solely and specifically designed and engineered components for the installation. Do out-of-state suppliers need to be registered with Department of Labor? Yes, they do. Good luck in getting that done, but they do. International suppliers need to be registered with Department of Labor. Again, good luck getting that done, but they do. So again, this is going to be a nightmare. It's going to be litigated, but at the end of the day, it's here. There's no sense in regretting what could have been. We'll deal with what is. The registration scheme. This is what came in effective last December 30th. It applies to everything now. At one time it had applied to bids submitted on or after, work commencing after, but by this time we're here. Contractors and subs wishing to bid work or perform work on prevailing wage projects. And again, this is prevailing wage projects, which now includes private work. The off-site fabrication was an exception to the covered private project rule. We're back to dealing with prevailing wage in general, which does include those private projects that are now paid prevailing wage. So, you have to register with Department of Labor. You log on to the Department of Labor website using your ny.gov online ID. Here's the website. You want to go to new application and look for public work contractor certificate. There's no mail-in option, no paper. It's online only. Welcome to the 21st century, folks. What about material not fabricated or equipment being delivered? I'm not sure what about material that's not fabricated or equipment being delivered? If it's not aggregate, then drivers do not need to be paid prevailing wage, if I'm understanding that question correctly. The prevailing wage for drivers only applies to aggregate as it's been defined by the Department of Labor, or in the downstate region, concrete and asphalt as set forth in the statute. So you've got a truckload of Mitsubishi equipment that you're delivering to a prevailing wage job. That trucker you can pay open shop. Okay, now getting back into the registration scheme and a few red flags here. As a part of the application projects, you will be asked or have been asked, do you have any outstanding wage assessments with a government agency, or have you been debarred within the last 8 years under state or federal law? Notice that doesn't say New York State, that just says state. So you had a problem in Connecticut, got debarred over there. Now you have to report it here, provided that happened within the last 8 years. At this point, it's not going to prevent you from registering, but it's a data point that's being collected. Okay, what about repair and maintenance work at a public site that's not under a specific contract? Okay, we'll deal with certified payrolls a little bit down the road. I know that these questions are coming in. I've got some questions that were sent over in advance as well, but we're working our way there. Okay, so again, not just New York. Now, another red flag is here's some additional data being collected as a part of your application. You have any determination for violation of labor law, employment tax law, that's unemployment insurance. Have you ever, slipped on providing workers' compensation insurance? Have you ever had a violation or fine from DOL about wage reporting? They're collecting this information. Further, do you have any final determinations for any law dealing with workplace safety standards, including OSHA? Now, again, my line to clients who discuss, well, I have an OSHA violation, it's an other than serious, or it's right now it's a serious, can I negotiate it down? It's never about the fine. It's never about 10, 12, or 17, or however many thousands of dollars, some kind of a 5-figure fine. It's always about the ramifications later on. If there was an injury and there's a personal injury action, you're going to want to fight that tooth and nail. Similarly, now that you have to disclose final determinations, willful, that makes sense. Serious, that makes sense that they're collecting this data. Repeated, again, you've been told something, it keeps happening, the textbook definition of insanity, doing the same thing and expecting a different result. Failure to abate, we're told to fix it, you didn't. Okay, again, there's a certain logic to collecting this data. Other than serious, they're collecting this data. De minimis, that's Latin for minimal, as you can tell from the sound of the word. They're collecting that data. So be warned that, if I had to put a couple of bucks on a bet, a couple of years down the line, after Department of Labor has collected this information, somebody's going to take a look and go, oh my God, X percentage of contractors have OSHA violations, or have this, or have that problem. So let's now make them non-registerable. So I suspect that's coming. Again, it's my gut feeling. I don't know this for a fact. I hope not. I hope I'm wrong, but I don't think I am. Okay, $200 fee for registration, $100 if you're an MWBE, plus a service fee. When you go through the registration, if DOL requests information, must be followed up within 48 hours. Otherwise, your registration will be deemed abandoned. You must also submit upon your registration and upon further request your workers' comp policy information. and uploaded at the time of the application. Information is going to be made public. There's a website, data.ny.gov. It's a little kludgy to navigate, but once you get the hang of it, you can find this information rather handily. And there are people who are very familiar with the navigation of this website. Certain information will be redacted, but it will be public. Your registration is good for 2 years, to be renewed 90 days prior to expiration. Department of Labor, they've done a yeoman's job in getting this system up and running. Once it was up and running, I had clients that were registering at the beginning of once it was open, 4 or 5 days before they got their registration. Towards the end of the process, it was being turned around in a day. So kudos to DOL on dealing with a deluge of applications and getting them done. And DOL will be facing another deluge in September of this year, which is 90 days prior to when everybody first registered in December. Here, the commissioner promulgates regulation to determine fitness to be registered. Again, this is where my gut feeling that further regulations are coming. So look out for a notice and comment period. Right now, the regulations, they mirror the statute. Current debarment is the only ground to determine unfitness. Again, beware the use of this other information to add to those regulations. Unfitness determination can't be based on a prior debarment unless you're still debarred. And again, as a practical matter, if you're debarred, you're not bidding on mom and apple pie prevailing wage. The effect of this is this now expands that to covered private projects. Here's a question. What is the line of delineation to define custom offsite fabrication? God, I wish I had an answer for that. Department of Labor is going to take a very expansive view of this, if history is any judge. For my clients, I'm going to take a very narrow view, and this will have to be litigated. That's the drawback of a new statute, where something's not, where a term isn't defined, it will be defined through practice, through administrative regulation, or litigation when an issue comes up. A determination of unfitness also can't be based on a subcontractor's failure to pay wages if the upstream contractor made good for the sub. Again, wage theft issues. So that sub would be determined to be unfit, but if the contractor ultimately made good on it, that contractor is not going to be jammed up. If there is a determination of unfitness, should demand a hearing within 30 days. I or somebody like me should be your first call when you have a determination of unfitness, so we can get the hearing process started. If you don't make that application within 30 days, you're effectively determined to be unfit. You've abandoned you've consented to determination, and it's made a final determination. If the registration lapses on the project, the good news is that you can finish your work on that project while you're pending renewal. If it's canceled because you've been determined unfit while you're on the project, the contractor can finish the work, but it's going to be under the supervision of a DOL monitor. Now, the obvious question is, who do you think is going to pay for that monitor? It's going to be on the GC or the prime. If it's a sub, what the GC wants to do is include in their contract, or an upstream sub wants to do is put in their contract that if there's a monitor appointed attributable to that subcontractor will defend and indemnify and hold the upstream contractor harmless from any resulting costs. Look, if a subcontractor has a problem, the subcontractor should pay for the problem. So you want to make sure that at the end of the day, the burden is on the proper party. Okay, if you're determined unfit, how long does that apply for? It's a 2-year registration, so you can apply again after 2 years. It's not a permanent scarlet letter, but this is something that would have to be addressed during the course of that application. Okay, more PRC number information. I will get to that because that goes to the certified payroll. Violations of the scheme. Unregistered contractors can't bid on public works projects. Now, you would think this would be simple and known, But a big problem, we'll also address this in talking about the certified payroll requirements. You have your sophisticated public entities that do work all the time. DASNY, the New York City School Construction Authority, Yonkers School Construction Authority, larger districts, Albany City. But you also have your smaller villages and towns and smaller school districts where public works projects are not routine. They'll do something every few years. And unfortunately, these owners' representatives, they might not be fully up to speed on the requirements of the imposed by statute. A lot of them think that their function is to argue with the contractor about everything on behalf of the owner, but they also have the obligation to put a buildable bid set together and a legal bid set together. In the year plus since the registration scheme came in, my firm's already encountered two smaller villages where they were about to award contracts to unregistered contractors who bid in violation of the statute. And we were able to obtain temporary relief in court prohibiting the award because it wasn't a legal bid. Obviously we were representing second low bidders, and anything a second low bidder can do to knock out a low bid is something they'll undertake. So again, you may be dealing with unsophisticated entities. So this is something that you want to keep an eye out for. Unregistered contractors and sub also can't commence work on a covered private project. Again, the bidding process for a private project may be simple as an owner calling a known contractor, hey, I've got something I want you to take a look at, and it starts from there. There's no formal bid. So in that situation, the GC, and of course subs, because they're not submitting bids on a public project, they're dealing by definition with an upstream contractor or private party on a covered project. They can't commence work on a covered private project. Certificate of registration must be provided at the time of the bid. Again, providing your owner's rep has put together a bid package that calls for it. I tell my clients, provide it anyway. It's a piece of paper. And in today's day and age, it's not going to save any trees to just keep one piece of paper out of the bid pack. So keep it in there. It may also highlight to the owner's rep that they have a problem because they didn't call for this, and not every responding bidder will be submitting it. Okay, another question. We manufacture precast and pre-stressed concrete. New statute, posted pay rates will apply only on projects that are bid after June 16th. Yes, that is exactly the case. If it's bid before then, you're covered under the old scheme where you can have, your shop working at open shop rates. But if it was put out for bid after that date, then the off-site manufacturer will come into effect, and you want to price everything accordingly. Okay, now returning to the registration scheme, upstream contractors, they have the same responsibility to verify registration status of subs before they commence work as the owner has of them. So it flows downhill. Violations of any of the above, $1,000 per. It's a civil penalty. Again, you're writing a check, so civil might not seem so civil, but it's not a criminal issue. And obviously, a registration may be suspended or revoked if a contractor violates prevailing wage requirements. Okay, people, here we are, the moment you've all been waiting for. Electronic submission of certified payrolls. This was also to come into effect last year, but given the amount of work that both 220I and 220J put on Department of Labor asked for and received a promise to submit a chapter amendment to the law, which was done, pushing this requirement date back to December 31st. And that was done, and now it's here. So contractors and subcontractors working on covered prevailing wage projects must submit certified payrolls to the Department of Labor monthly in electronic format. Now, covered private projects or traditional prevailing wage, the question is, hey, does it apply to maintenance contracts? Does this apply to small contracts? The answer is, if you're paying prevailing wage, then you're filing these certified payrolls. It's that simple. Um, and again, not every entity is sophisticated enough to um, have a PRC number, update a PRC number, prevailing wage rate case number, what it stands for, um, and they're not prepared. This is something that needs to be brought to the attention of the Department of Labor, that they have work to do on the compliance side. And by compliance, I don't necessarily mean that they need to make sure that contractors and subcontractors comply, but that the agencies responsible for the administration of the certified payroll, the prevailing wage work, do what they need to do. And also, with private projects, obviously if something goes through the Public Subsidy Board process, it's going to get a PRC number. If it's certified, that's how those projects get their PRC number. Now, monthly is defined as once every 30 days while on a project and within 30 days of the end of the work. So, that there's that little trick about, how you remember days in a month. There are months with 31 days. Ostensibly, if you point out July and August each have 31 days. So if I do it monthly, I'm by default late. Well, there is a 14-day grace period. So if you do it monthly, you're within the grace period, even during the summer months. Importantly, this will be searchable by the public and organized labor. That they were chiefly behind the move to enact this statute, and it's here. And again, it's for the reason that, Department of Labor, again, they do a yeoman's job with what they have, but they only have what they have. Inspectors are overworked and underappreciated. So in order to assist them, this information will now not only be foilable, it always was, it will be in a public database searchable by the public, that data.ny.gov site. Again, the information will be redacted, so you don't have to worry about names or social security numbers, but they'll be able to tell how many men or women you have on a job and what you're paying them, etc., and whether it's within the range or whether something needs to be highlighted for an inspector to be able to focus on any particular entity. Also, you have to provide documentation for any fund to which supplements have been paid. And this is a crucial one. You have to provide your payment bond information. I know that as a construction lawyer, I have started any number of payment bond lawsuits. Unfortunately, sometimes the client comes in. There's only a matter of days to meet the statute of limitations on the bond, and I don't know the bond, and the contractor didn't get it at the beginning of the job. So, which is when you should get it, when everybody's still in that kumbaya, let's go along to get along. Because when you need it, when you're not getting paid, and you're calling up somebody that's not paying you, hey, can I get a copy of your payment bond? Good luck and God bless with that. You're not going to get it. So now that it's going to be online, what it does is it enables a direct suit against the surety, and the surety and the bond number. There are no more lawsuits are going to be needed against John Doe sureties numbers 1 through 10. And then when you find out, you move to amend and bring them into the lawsuit, and then you have a fight about whether they knew or should have known, and whether your lawsuit relates back to the claim, and you avoid a fight. Okay, a couple questions. What if your contract doesn't require a payment bond? Well, subcontractors, let me put it this way: when the prime contractor sets up the job, they're going to be asked for the payment bond information. If there's no bond, there's no bond. Some smaller projects, some smaller jobs don't require a bond, so there will be nothing to upload. If a prime contractor requires a sub post a bond, that's a private bond. Yes, it's in the context of a public works project, but it's not a bond that's required under Section 137 of the state finance law. So that bond does not have to be uploaded. It's the general contractor's bond, which gets uploaded. Bulk uploads, we'll get to that, but the question is yes. The answer is yes. Okay, one-time emergency job, no PRC number, service calls. Again, if you're paying certified payroll, if you're paying prevailing wage, you need to do certified payrolls. And this is, again, something that the industry is going to want to raise with Department of Labor, that not every smaller entity will have issued a PRC number, have set something up where you can where you have an easy ability to submit. On the other hand, when you do a submit, as a practical matter, you may be opening and closing a project with 1 day's worth of certified payrolls. Yes, it's a nuisance. No, I didn't think it was a good idea. It's here. We're dealing with it. Okay. New York City has their own website. Yes, New York City, the statute does delegate to the commissioner of New York City comptroller the option, which they have opted into, to submit to them. No, you don't have to double submit. How do you get a PRC number? You got to talk to to the public entity. Okay, the mechanics of compliance. You no longer have to submit to the Department of Jurisdiction, only Department of Labor. Again, you're not submitting to the public owner now. Department of Labor takes that burden off of the public owner. That being said, the wage theft ramification I discussed earlier, you still want that independent obligation into the contract to provide certified payrolls upstream to verify compliance with the payment obligations. That is and the statute, the wage theft statute, permits you to withhold payment from downstream contractors if they don't provide this information. I would also put that in the contract for clarification, make it a condition precedent to payment. That is a legal condition precedent to payment, providing certified payrolls, unlike payment from upstream. So you're going to want that information. This way, if you get called on a wage theft issue, you at the very least have the ability to defend yourself against a willful charge. Again, there is the 14-day grace period to submit documents, $100 a day after. And Department of Labor, they know there are issues, and they've been reaching out to the various contractor associations around the state. AGC, subcontractor associations, New York City STA, NESCA up in Albany, and whatnot, and have advised, look, we know there are going to be issues. We're going to be reasonable about this. And we recognize that there is a 14-day grace period. So as a practical matter, they're not expecting anything before early February. Okay, just to confirm, we do not have to submit certified payrolls to the job owner only Department of Labor. Yes. Billing, school district, do we no longer, when we do our billing for example, school district, do we no longer have to send invoice with the certified payroll? Yeah, you don't have to send it to the owner now. You obviously still send your invoice or payment requisition. They may want to see it. And again, since documents are foilable, publicly available, there's no harm to providing them. But now there's no requirement. As of right now, Department of Labor has a complicated XML format to upload bulk employee data. Anything simpler? No, XML is the upload. That is the bulk upload. If it's complicated, it's going to be complicated. Hopefully they can streamline that process. Several jobs running. They do need to be uploaded individually per project. You can't do a bulk upload of multiple projects. What obligation does an owner or CM have to ensure contractors and subs comply? Well, the compliance with the certified payroll requirements will be undertaken by Department of Labor. So the owner does not have that obligation. Okay, would it be an issue if the county does their own work and does not require a bond? Well, if it's county employees, then that's direct work. That's not a contractor coming in. If that county that you're talking about subcontracts out work, that's a prevailing wage project. So county's not going to bond itself, and a county is, like any government entity, is presumed to be solvent for its financial obligations, so that's not an issue. As a project owner, can we require a contractor report to us as well as the state? Not only can you require it, you should require it. That's the wage theft obligation that's up on the screen right now. OGS emergency jobs still requiring upload of certified payrolls. Okay, if your owner wants it anyway, again, there's no harm in doing it. But they don't have to require it. Do you need to submit for subs on the job, or are they responsible for your own to do it on their own? They're responsible to do it on their own. The prime or the GC will set up the project once the job's been awarded and advise the sub of the PRC number so that the sub can find the project and then upload to it. But the subcontractor is responsible directly. Just to confirm, well, I'm being specifically asked about the New York City School Construction Authority or Port Authority. Look, whatever those owners want. Again, there's no harm in giving it to them. If they don't want them, then you don't have a requirement to submit them. Okay, multiple jobs with the same PRC number, you can't enter the project. You do need to reach out directly to DOL and your owner. Hey, why are these multiple jobs on on one PRC number? Davis-Bacon work doesn't apply. If it's governed by Davis-Bacon, you have the federal requirements, and these requirements do not apply. Precast manufacturing facility, who at the plant is paid prevailing wage? Is there a line? Yeah, everybody who's manufacturing and your supervisors, everybody it wasn't passed over. It was mentioned that everybody who's in the process of manufacturing, the workers, will get paid prevailing wage. Temp employees with a temp agency, does temp agency upload on their behalf? They're not a subcontractor. You're the contractor, so you're submitting on their behalf. Penalties are assessed only against a non-compliant contractor. This emphasizes that the responsibility to file can belong downstream. It's not everyone in the chain, unlike the wage theft obligation. Okay. Department of Labor is aware about multiple users the same PRC number. These things are coming in fast and furious. My apologies. Department of Labor is aware that users are presently unable to enter same PRC number for multiple projects. It's being addressed and system will be updated shortly. Okay, way to go, DOL. Again, they know it's a brave new world too, and they're doing yeoman's work in addressing it. But unfortunately, it's like the game whack-a-mole. The head pops up over here, you hit that. The head pops up over there and there and there, and there are going to be these growing pains and bugs worked out of the system. What information do they need for supplemental benefits? They need you to upload the documents showing that you paid them. Okay, here. New York City Comptroller has to be provided with data, and Comptroller has the ability to enforce. So if it's a New York City project, the Comptroller has the option to let the state DOL take the lead or collect the payrolls for themselves. Ask your public owner, if you're working in New York City, to which entity do you report, do you file. So the mechanics. Okay, condition precedent for DOL submission still apply if prompt payment provisions. Well, you want to, like I said, you want to get the certified payrolls for yourself, but the obligation to upload them is on the subcontractor. If they don't upload it, that's their issue. Okay, we are a sub. Should we rely on the prime to set up the project with DOL for reporting? Yes, the prime has to set up the project. They're going to be the ones to input the PRC number. They're the ones going to be the ones to upload the payment bond. If you're a sub, the first thing you're going to be asked is, for your payment bond, and you're going to go, what? And it's going to be the kind of job where there is a payment bond. So you want to get that information from your prime or upstream contractor. Mechanics of compliance. You want to log in with your ny.gov account. Now, an ny.gov account contains a lot of information for your company's interaction with the state of New York, including Department of Taxation and Finance. Yes, tax returns. So needless to say, you don't want to go giving out your user ID and password for the simple, to an employee who shouldn't be seeing the corporate tax returns, just to upload certified payrolls. So you can set authorized users to use a portion of your ny.gov account without general access. Are subcontractors notified by DOL if a contractor has included them? I don't know the answer to that question, but if you're on the job, you should, raise your hand and proverbially and sign up. Do we upload union rate sheets? Yep, that's how you would do it if you're a unionized shop. So what you're going to do is you're also going to look, I imagine a lot of you have by now, at a step-by-step user guide. And again, this gave some preliminary information, and DOL knows of issues and they're working bugs out. But you're going to need, at the outset, your federal tax ID number and your contractor registration number. And again, here, even the state site points out that, hey, you may be, if you're working in New York City, you may be subject to the comptroller as your fiscal officer. So ask the entity whose job it is. Ask the public owner, hey, where do I submit these? State Commissioner of Labor, the New York Department of Labor, or City Comptroller? Okay. Where an employee's base hourly rate exceeds a prevailing wage base rate, but value is lower than prevailing wage requirements, can higher base rate be used to offset lower supplement? If you're talking about a situation where the lower wage rate, the lower supplemental benefits, the supplemental benefits value is lower than the prevailing wage rate, and you're unionized, again, the fact that you're paying fringes to a union, they get other benefits as a part of being a member of a union, and those count towards prevailing wage. So that's what union. Okay, then how is the value of supplemental benefits provided lower? This may be an individual question to well, difference must be paid in cash, yes, but how then it's prevailing wage compensation if you're paying, part of your fringes in benefits, and then the difference in cash. That's how you make it up. Are you specifically talking about just the value or the value in the cash supplement? Again, that sounds like an individual question. I'm happy to have a chat offline about that. Here with the EIN and the contractor registration number, you need those, and your PRC number, as you all know well. Here, certified payrolls. First thing you're going to do is, as part of uploading, you're going to upload a copy of your payment bond, supplement pay documentation. It says optional, but it's Department of Labor needs to see it. Can a difference in base rate be used as cash in lieu to offset part of the fringe? Okay, I guess that's a clarification on the prior question. If it's a non-union shop, then yeah, you can use cash in lieu to offset that part. Again, it all goes into the paycheck. You're paying payroll taxes on it, but it is what it is. When you register, here's what you're going to be doing to set up the project. Enter your name, following information, your PRC number. For purposes of compliance now, many of you, all of you, etc., are working on jobs that were bid and let, and you're already working. So if you enter that, hey, this project started in March 2025, the system will update it and deem your start date as January 1st. Therefore, making your first certified payroll due January 30th. You may have already answered about cash in lieu. Yes, if you're paying cash in lieu of fringes, you can do that. You're paying payroll taxes on it, but yes, you can do that. Also, subcontractors should search to find projects already set up by the prime. Again, you get the information from the prime and the GC to make it easy. Once the project's set up, only minor changes can be made. End date, okay, project delays happen. What subs are on your job, and new bond information. Your bond may have expired. You may, the requirement is not to, keep one bond in place. You can replace that bond. It's a bit of a hassle, but you can do it. It only requires that a bond be in place. So that change can be made. Okay, certified payrolls. You go to your dashboard, it will list your projects, and you can add new projects as they go. So it's looking like an intuitive website. Again, we all know there are growing pains, but so far, Department of Labor's done this, has set this up to make this as user friendly as possible. Okay, when you get into the system, you can add an employee. You can copy a prior week's payroll. You can also upload an XML file for that bulk upload. Again, from what I understand from the questions that are scrolling in, it's a bit kludgy, but it may be a matter of getting the hang of it. It may be a matter of the industry needs to chat with Department of Labor about streamlining the XML format, but you can do it. And for certain weeks, there may be weeks where there's no work going on. You can simply, as far as your reporting, no work this week, and that's that. Okay. Precast 6 or 8 jobs as well, simultaneous. How do you suggest we attempt to sort out number of minutes? Yeah, this is exactly the issue with that with the requirement for offsite manufacture. How do you sort? How do you segregate? Again, they go into some detail about the plant operator, the laborers, forklift driver, crane operator, then shipment on your own trucks. Well, shipment on your own trucks, again, unless it's aggregate, then that's not prevailing wage. Statute does not apply to delivery, so I don't have to worry about independent drivers. We have days where trucks may travel into central New York to make deliveries at 3 or 4 Davis-Bacon jobs. And then the most prescient comment I've seen, this is a nightmare. Right, it is. But yeah, the industry is going to be left to figure out how to do this. And again, the state in enacting this did not put any thought into the administrative burden that they were imposing. But again, it's here. Slides at the end, yes. Do you need a PRC for service repair? If you're paying prevailing wage, yes, you do. Because you need to upload those payrolls. And again, you may be creating a project, uploading a payroll, and closing a project all in 10 minutes. Can you set the work week if you don't follow Monday to Friday, run payroll from Wednesday to Tuesday? I believe you can. Again, the Department of Labor realizes that, and when January 1st being a Thursday, they realize that Thursday to Wednesday is a frequent pay and payroll cycle, but it's not exclusively the payroll cycle. So again, you can do that. Does this apply to this applies to all prevailing wage work you're doing? Again, if you had a start date prior to January 1st, you don't need to upload any certified payrolls that were involving work in 2025. Your start date will be deemed January 1st. So if you do have the proverbial Monday through Friday work week, and therefore your work week would have started on January 1st, holiday, nobody's working. Your work week had ended on Friday, January 2nd. There's your work week. Even though the project may have been going on for months or more. Importantly, the website will indicate when the payroll is due. You can copy a prior week's submission. You can, in using an XML file, this is only for, you can't split a submission. You can use a bulk submission, but you can't submit, no work week manually and then XML in bulk. You've got to do, if you're going to use XML, you've got to do it for everything. Okay, more questions. Employee to be eligible has to be entered individually or just upwrote. You've got to enter your employees. Again, you're doing that through an XML or you're doing it manually. And here's the add employee slide. If you have no prevailing wage until spring, you still have if you still have to log on and claim no work week now. Well, if you're not on the job, then no. If you've been on the job and you're taking, say, a winter break, maybe you're maybe you're a roadway contractor. Then look, if the job is ongoing, you're just not doing any work at the time, then yes, I would start that now. The good news is once you start entering employees, they stick on your dashboard. So you don't have to enter an employee every single time. And again, you can copy prior weeks. You can click no work. It will populate as it goes. And again, your due date is highlighted. A requirements contract, when would you close out the project? When the contract is finished. You do have to either report a no work week, or if it's an extended work stoppage, then you would report that to Department of Labor so that you don't have to go in every week and click. But that's how you would do it. And if work's not called in, do you have to go and submit? Well, again, if it's a kind of contract where you can get called at a moment's notice, you really can't anticipate when you're going to be starting up again, so you're going to have to do it week by week by week. However, if for instance you're a plumber, you do the basic rough in before the slab goes in, before the slab gets poured. Okay, now you're off the job for a while, and it's anticipated you're going to come back in 3-4 months or whatever it is. That you have an idea as to how long you're going to be off the job. A requirements contract, not quite. Training program scheduled to take place in April, but it's considered to be can value that training be applied to January certified payroll. Okay, this sounds like an individual question, so reach out to me offline. Why does it ask for an OT rate? Well, because if they're working more than 40 hours, that's why it asks for an OT rate. So proposed amendment that will include just like aggregate. I don't know. I would say it's by proposed amendment, I'm sorry. The question is, do you know if there's a proposed amendment coming that will include asphalt and concrete drivers like the aggregate drivers? Again, I suspect that the Department of Labor regulations applied to enacted for aggregate will be applied to asphalt and concrete. But I don't know if there's any amendment coming to the statute itself. So all I can say is stay tuned. Okay, yeah, the overtime rate applies to the base rate, correct? Do you have to fill out inputting payroll if you uploaded payroll? No, if you've uploaded an XML file, that is your submission. And then here's the certification part of the certified payroll. Yes, you are just simply clicking. You no longer have to get these documents notarized, but these clicks are the equivalent of having a document notarized, which is where you state under penalties of perjury that the information contained in there is true and accurate. And again, if it's not, it's a potential perjury problem. And again, you have the ability to click, okay, final work week. Hey, I'm done. Click, then that will close out the project. So again, a couple other questions about the PRC numbers. I've answered those. And again, the need for smaller school districts, villages to get compliant. These issues, I believe, have been brought to Department of Labor's attention. And should obviously bring these to the attention of your smaller public owners where the problems are arising. But at the end of the day, Department of Labor, they are being patient, but ultimately the situation can't last forever. Either these smaller entities are going to have to get with the program. They're going to have to issue PRC numbers and undertake the administrative burden of this. And again, what's fair is fair. The state saddled the industry with this requirement and the administrative burden. So, these smaller public owners are going to taste that as well. So with that, that's the end of the program so far. Again, it's Department of Labor. They are hosting webinars themselves with the mechanics of the compliance. All of these nuanced questions about, and again, I imagine they will get an earful at any one of these about, hey, my small school district hasn't issued a PRC number, or they're already aware, as the commentator mentioned, that some districts are using the same PRC number. Well, that will be and some other owners are doing the same. That will be an issue as well. Okay, if someone reports a final work week and then gets called back for some punch list work, then can you reopen a job? Yes, you have to. Again, this may be a question for the Department of Labor Help Desk. That's the mechanics of doing so. But obviously, you're going to have to pay certified payroll, so therefore, a pay prevailing wage. So therefore, you have to provide certified payroll. If we pay our supplemental benefits on the 15th of each month to different programs, when would they be uploaded? Well, if you pay them on the 15th of each month, you have your 30 days to submit and then a 14-day grace period. So they would not be outside of the 14-day grace period. If benefits are paid in cash, how do you show documentation? Well, by cash, if you mean a check that will be cash or a direct deposit, that's your documentation. If you mean cash in good old-fashioned Yankee greenbacks, you're going to want to get employees to sign receipts. So again, the days of paying in cash are, with all of these requirements coming on, they are fewer and further between. And again, if you're paying employees in cash, it becomes a proverbial he said, she said. And keep in mind, for wage theft purposes, that there's no such thing as something that's analogous to an employee lien waiver. It's not a defense to the action that the employee signed something acknowledging receipt, because the theory, in so goes the statute, is that, well, the employer can make the employee sign everything on penalty of being terminated, penalty of some other work penalty. So therefore, they're not given credence under the statute. Okay, if a school district were to come to our yard and pick up a stock product from the yard, do you need to go back? Well, if it's a stock product, it's not custom fabrication. So, if they, again, just using a Home Depot type of an example, they need a 36-inch, cabinet cutout for a sink, it's an off the shelf. So if it's a stock product, then it's a stock product. So with that, I've taken a lot of questions, and I'm happy to stay here as long as questions keep flowing in. I'm getting some thank yous, and you're welcome. Happy to help. Obviously, there will be more questions that come up. You all have my email, gspaun@WB&G LLP.com, and I'm happy to answer any further questions that may come in. I have everybody's email addresses, so I will send out a copy of the slides. Recording, yes, you got the prompt upon joining that this is being recorded. Take me a couple of days to clean it up, but it will be posted as a recording. Okay. Do you know how monitors will be selected? There are consultants out there that I presume, we're talking about registration now, and if somebody's determined to be unfit, you need to drag them across the finish line, as it were. There are these consultants out there at Department of Labor. They know who these consultants are. They are able to be found on Google. Again, I would start with Department of Labor because they're the ones who are going to be accepting the reports of the compliance monitor. And again, make sure your contract provides that there's a flow down for those costs. How do you find Department of Labor seminars? I know that AGC, Associated General Contractors, sent out an email right before I started this program, highlighting that there's an upcoming seminar free. I believe it's on Friday, but they're out there. So for anybody who is not a member of a construction industry association, I highly recommend them. For general contractors, for subcontractors, for different unique trade contractors. DOL is reaching out to these organizations, and they know they have to spread the word, and these organizations are among the quickest way to do it. So I'm sure, maybe Googling something at Department of Labor. I would imagine if you go to AGC's page, and I'm sorry, Joe or anybody else who may be online, your website's about to take a hit, because that's the one I got literally right before. But again, keep an eye on the trade organizations, the contractors organizations, for information about these. Department of Labor website. Okay, programming and IT support. Okay, that's not custom manufactured goods. That's a service. So I would say no, that's not included. Perhaps an argument can be made if you're, they're cutting their own cabling, that the cabling is for, but again, for the sake of avoiding prevailing wage, you might just want to buy stock cables, not need to cut them, and yeah, you're paying a couple of dollars more on the material cost, but you're avoiding prevailing wage, which is your big cost. Okay, and with that, again, for a lot of thank yous, you're welcome. And if you have any further questions, by all means, reach out. Oh, no, new one. Glass cut to size, purchased for a vendor. Yeah, if it's cut to size, it's not an off the shelf product. I would say yes, it does get included as custom manufactured, specifically for. Again, my analogy of HVAC units. Again, that they're manufactured to manufacturer specs, and that's why they're called out by your designers. But say it needs a little bit of a modification to install it on the project. Okay, how much of a little bit of a modification will change this from off-the-shelf material, a pure supply contract, to custom manufactured and therefore a labor contract? That's the issue that's going to be litigated. So, okay, question. If you're a vendor, supplier, manufacturing something for a contractor, do you have to register for something for Department of Labor? If it's specifically not off the shelf, if it fits that definition of specifically manufactured for that project, then that supplier becomes a prevailing wage contractor, and they have to register. Even if they're in Canada, even if they're in Pennsylvania, even if they're in China, there's no geographic requirement. So it applies to offsite wherever that offsite is. So again, I'm not here to have the argument, is this a wise idea or not? You obviously know my opinion on it. I'm just here to tell you what's here. So my apologies on being the bearer of bad news, but as an attorney, I do that quite often. Occupational hazard. Okay, even though no certified, it's a follow or up. Even though no certified payrolls are used by the vendors, well, they're going to have to. That as a part of becoming a prevailing wage contractor, they will have to do certified payrolls, and they may just decide, and we anticipate that there will be a tranche of suppliers that you will no longer be doing business with because they don't want the administrative headache of doing business in New York. There are some that will, depending on the volume of business. Again, you're talking about a small fabricator across the state line in Pennsylvania who predominantly does New York work, supplies to New York projects. Then yeah, that contractor may ultimately say, okay, I'm registering as a New York State Department of Labor prevailing wage contractor, and I know I'm going to have to do certified payrolls. Mitsubishi Electric, however, you're not going to really be able to have that conversation. Again, Yeah, the comment is wow. Yes, wow. And with that very prescient comment, I will leave everybody. Again, thank you all for attending. If you have any follow-up questions, by all means, pop me an email. Oh, one last one. They would need to register with Department of State. Yes, if they're doing business in the state of New York, yes, they will need to register with Department of State. If they're doing business in the state of New York now without being registered with the Department of State, that's a violation. It's a curable violation. It's basically paying back franchise fees and taxes. Um, but yes, that would be a, a requirement. So yes, again, the burdens to do business in the state of New York are ever increasing. Again, if you have any further questions, I'm happy to take them. And with that, I thank everybody for the attendance.